Under the statute that authorizes this court to deny bail in certain circumstances, and this would be one of those circumstances where a defendant is charged with aggravated murder. The main focus is on the safety of the community. In the context of the standard that you articulated earlier, that is, the state has the burden of proving by clear and convincing evidence that the proof is evident, or the presumption great, that Ruth Miller committed the crime of purposely killing Vincent Miller, her 4-year-old son. That she is a substantial risk of causing serious physical harm either to herself or others. And that no release conditions would reasonably assure this court of the safety of herself or others. And so, Your Honor, I began by saying this is not a whodunit, or even what did she do. This is a mother who had struggled with some stressors in her life, some mental health issues, reportedly, such that it had concerned her family and her church, and they had some intervention the morning before they left for Atwood, and felt that they had gained some headway, that it was somewhat beneficial, that it would be good for them to get away and decompress, and certainly had no idea that something like this would happen. It seems very clear that also they had a good day on the boat Friday, but that Friday night, when the kids were in bed in the camper, Ruth and her husband felt some inspiration to go out to the dock and do some tests of their faith, and they did that. And then later in the morning, they came back to the camper, that she reports that Marcus left again on his own volition to swim to the sandbar and never came back, is what she, and that was the last time she saw him, is what she said. She ends up going out to the pontoon. She says that she witnesses his clothes left on the pontoon. The same clothes that responding officers also saw on the pontoon. And the same clothes that Marcus Raber said at approximately 6:30 a.m. he saw Marcus Miller wearing when he confused him to be Bobby Miller. But when Ruth went out there, her husband was not there, is her report, and that she began to spiral. And she went back and she got her son Vincent, and she took him to the dock. And she's very clear in her statements to Adam Fisher at the hospital as to what she did. It may have been somewhat vague in the field to the initial responders, that I threw him in, that I gave him to God, but she was very clear with Adam at the hospital. And that is, she said that she felt she should throw him in the water, that she threw him in, that he came back up to the surface and looked at her, and that she questioned whether she should be doing this. And her statement to Adam at the hospital was that she felt that God was telling her to walk away, and she turned around and walked away. Now, Then she went back and got her other children and brought them out, had them perform some tests. That they were praying intently near the kayak dock, that they got into the golf cart and then raced down to the bistro and over the rock embankment and into the water. And that's when the 911 call came, and that's when we get involved. At the scene of where she wrecked the golf cart, it's very clear that she was uttering many things, such as her husband and son are in the water, that she gave them to God, and it was concerning. The rangers directed her to show them where that was, and she began with the children to walk away from that area, but quickly that accelerated into a dead sprint, according to the ranger, and they essentially got away from the rangers and the one deputy who had responded. And Ruth was missing for nearly 30 minutes and found eventually lying face down in high weeds. And when she is recovered, she continues to talk about these irrational thoughts about that she was doing the will of God, that she had given her husband and her child to God, that she threw her child off the dock, is what she said in her excited utterances when she was recovered from hiding or from lying down in high grass. But it's interesting that she's missing for a half hour, that she's has a lot to say to bystanders and to initial responders right after the crash, that she has a lot to say to initial responders and bystanders when she's recovered from the high weeds, but she's remarkably quiet and undetected for 30 minutes until she is found. There's no question who done it and what she did. And the defense has made some remark of whether she committed the act, as that word is construed in the law. I would urge the court to take into consideration the law as it relates to natural consequences. And juries are instructed on this in many cases. A defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is responsible for the natural and foreseeable consequences that follow in the ordinary course of events from acts or failure to act. So her act was to throw her son off the dock, her 4-year-old son, who couldn't swim well if he could swim at all. That was an act, and there's a natural consequence to that act. Whether she was delusional or whether she was malingering, at this point it really doesn't matter. That will be determined later at another juncture, I presume, when we determine competency and insanity. But for purposes of this hearing, it doesn't matter whether she was honestly delusional or whether she was malingering. The natural consequences of throwing a 4-year-old into the water is that he'll drown if not saved. And then when he resurfaces and he looks at her, and then she decides, for whatever reason, to walk away, the natural consequence is that she acted and she had an omission as well that caused his death. And the natural consequence is that that's her purpose. She's imputed with that purpose. So that's why I say this is not a whodunit. I think the proof is overwhelming whodunit and what she did. The real question is whether there are any release conditions, if you were to release her into the community, that could assure this court that she's not a risk of serious physical harm to herself or others. Now, we have just received both the defense and the state medical records from the Cleveland Clinic hospital, and you've not heard anyone testify from Cleveland Clinic that they can assure you that there are some measures that can be put in place that would safeguard not only Ruth, but her family members and the community. You've not heard that. That's not on the record. In fact, I think I can say that the records are fairly voluminous at both Union and Marymount. That she said a lot of things to a lot of hospital personnel. A lot of things consistent with what's been said here today and what she said to investigators and even more. That while she was in hospital care, she was generally regarded as polite and compliant, if not pleasant at times. And that she expressed that she couldn't believe what she did. At one point she said, the devil got to me in the moment. So, but again, whether God made her do it, whether the devil made her do it, whether she's faking it, or whether she's honestly delusional, for purposes of today, it doesn't matter. What matters is there's nothing that can assure this court that she's not going to have some break again based on whatever, based on a lack of sleep, based on misinterpretations of the Bible, based on something beyond what we're even discussing here today. It doesn't matter. What matters is, can she give some assurance to the court that this isn't going to happen again? And, Your Honor, given the gravity of what happened here, there is no ankle monitor that's going to assure the court that she is not a harm to herself or her family members. And there's no secured facilities besides the jail and besides some state hospital that either competency or sanity might dictate that she has to go to. But that's a procedure for another day. Short of a state hospital to be determined another day, or the jail facility, there's nothing that can assure us that she will be safe in our community, to herself, her children, or others. And so, Your Honor, getting into issues of why she did this, I think gets beside the point. The point is that she did it. What she did was horrible. And if it can ever be determined by forensic psychologists and by finders of fact in this court why she did it, that will be an issue for another day. At this point, Your Honor, I would urge the court to deny bail because no reasonable assurance can be given to this court that she can be safe to herself or others in this community. Now, one thing that the no bail statute doesn't address, but that just general considerations of bail does address, is flight risk as well. So, Your Honor, if you were to set a reasonable bail, I would urge the court to set a very high cash bail. At least $1 million bail. Because in conversations with the family, they have resources. And they could make a moderately high bail. They might make a high bail. And I would say this. She has 3 surviving children who love her. And who want to be with her. I don't believe she could provide any assurance to this court that she could not just leave the jurisdiction of the court, especially given the high stress that she's under at this point, and just really disappear into obscurity. Yes, she has ties to this community, but we don't know where she might have extended family. So I think that Your Honor can reasonably take into consideration risk of flight. And I would also say this, that I want to be a little measured here, but for teenage children, okay, there is a counselor involved with them, with at least some of them. And without the input of a counselor as to a good plan for having some kind of contact, I think the most prudent course is for the court to order no contact with the surviving victims here until further order of the court, and mainly until some mental health therapist who is familiar with the situation can endorse such a track or such a plan. So, first request, Your Honor, is that you deny bail, that whatever made her did it, her stressors are even higher now, and she can, being under indictment for this, and she cannot give any reasonable assurance to the court, and there's not been made any, through testimony, any articulation of a reasonable assurance that she'll not be a harm to herself or others. Therefore, Your Honor, I'd ask that you deny bail, that you order no contact with the surviving victims, and in the alternative,